Hello friends, I am Dr. Raman Mittal. I work at the Faculty of Law, University of Delhi. In this module, we shall be talking about assignments and licenses of intellectual property. That is, how intellectual property rights could be transferred by the owner to other persons, how the owner of intellectual property can invite others in participating in the exploitation of the works in which he has intellectual property rights. Now, where do you find licenses and assignments? What are the instances of it? We find them all around. Do we find it here in the bottle of a Coke? Yes, the bottle of the Coke that we consume comes to us only through the process of licensing of intellectual property. There are various licenses or assignments involved in the whole process of manufacturing, bottling and consumption of these soft drink bottles. Then the t-shirt that we wear carrying the logo of a famous character, that comes to us through licensing activity only. Then software that we consume is also subjected to licensing. In fact, we consume softwares as licensees rather than as buyers. In case of films, how the film comes to us, whether through broadcasting or through a cinema hall, it also involves the case of intellectual property licensing. The books that we read is also involving the case of licensing or assignment of copyright. So, we say licensing is ubiquitous, we find it everywhere. First, in order to understand the aspect of licensing and assignment, let us look at it from the angle of a lawyer. What are the tasks of an intellectual property lawyer? The first task is obtaining rights. The second task is, after obtaining rights, protecting those rights. And the third task is exploiting rights. So, obtaining rights and protecting rights cannot be ends in themselves, because what for are you obtaining rights? What for have you protected those rights? You have done so only with the aim of exploiting those rights. So, the fundamental task of an IP lawyer is to aid or to maximize or to monetize through the utilization or exploitation of intellectual property rights of his clients. Now, exploitation could be of two types: self-exploitation and exploitation through others. If the owner of intellectual property utilizes his own intellectual property himself, then is the case of self-exploitation of intellectual property. If the owner invites others or gives away his intellectual property to others for exploitation, then it is the case of exploitation through others, which is normally done through licenses and sometimes through assignments as well. Now, both licensing and assignments are transfers of intellectual property. So, let us go a step earlier and understand what is meant by transfer of intellectual property. Is intellectual property transferable? Yes. Intellectual property rights, most of we can say the intellectual property rights are transferable in nature. These transfers could take place either by the mechanism of a contract or a mechanism which is apart from the contract, which is, for example, by operation of law. For example, the owner of intellectual property dies, so his legal heirs will get the intellectual property which was owned by the dead person. So, but the most important one for our purposes is the contractual transfer of intellectual property. Contractual transfer of intellectual property could be achieved in the form of assignments, lease, license, mortgage or sale. All these are legally different and significant aspects and concepts of law, and they convey very different rights and very different meanings and very different consequences. Now, most important types of contractual transfer of IP or intellectual property is through assignments and licenses. So, licensing activity gets impetus from three fundamental aspects of law. First is the rights which are contained within intellectual property, they are of exclusive nature. This exclusivity of rights aids the activity of licensing. What is understood by exclusivity of rights? Now, the rights exclusivity means that the owner alone has the right to exploit his intellectual property. So, we can look at this aspect of exclusivity from one angle, that means the restrictive angle that gives the owner a right to exclude others. But the other aspect of this exclusivity is that the owner has the liberty, has the freedom to invite all others to partake in the exploitation of his intellectual property. Thereby, he will be allowing others, permitting others to participate in the exploitation process and also earning for himself some remuneration. So, this aspect of exclusivity really aids the licensing activity. The second aspect is the intangibility of intellectual property. Intellectual property, we understand, is intangible in nature. Now, the enjoyment or the utilization of this intellectual property being intangible property does not detract, the use of one person does not detract from its use by the other person. Potentially, any intellectual property could be utilized by any number of persons. It is in contradistinction with a physical property. For example, A owns a house. In case he wants to allow B to utilize his house, then the house has to be divided between A and B. So, that is not the case with intellectual property. Both A and B can have the same, and any number of persons can have the same property for its exploitation. So, this intangibility or intangible nature of the intellectual property also aids the licensing activity, because the owner can invite n number of persons for its exploitation. The third aspect is that gives impetus to the licensing activity is the freedom of contract. The law permits the owner to freely contract out his property. This freedom of contract also aids in the licensing activity. Intellectual property, as we have seen, has three limbs. First is creation of property, then second is protection of intellectual property, and third is its exploitation. So, one question is fundamental to this circle of intellectual property. Should a property be created first and then protected and then exploited? In other words, is it always the case that intellectual property is created first and then exploited? Well, that is not always the case. That may be the case in some times, but the modern practices of the market, if we peep into those modern practices, we find that exploitation of the property takes first and then the property is created only upon its exploitation. For example, there is a person who wants to make a film, he is a film producer. So, first thing he requires is a script. So, he commissions Mr. A to write a script for his film. So, for that he already pays Mr. A upfront a particular sum of money. So, can we say that the property, intellectual property, copyright was created first and then exploited in this case? No, because the property was subject to sale first and then it was created, because only upon an assurance of money and actual payment of some advance money that the author was ready to create it for the producer. So, in this sense we can also see the modern practices in which inventions are made. Employees are people are employed in business undertakings, they are given certain tasks, and before they create something they already have assigned by virtue of their employment contract to the employer the rights in all their creativity. So, exploitation many a time comes before creativity and protection in case of intellectual property.